I will offer up my own judgment that the source of the limit on parents' rights, the main source of the limit, and the reason why, even as applied, parents don't have a right to obtain these treatments for their adult child, minor child, is that these treatments, both pharmaceutical and surgical, or the Trump executive order refers to chemical and surgical mutilations. I think, in fact, in truth, these treatments are mutilations, and no parent has a right to mutilate their child.
This is Hadley here, taking the lead in our first podcast in the aftermath of the Skrmetti case, and I have Gerry Bradley here with me. Both of us, I think, are pleased with the outcome of the case, but Gerry and I both see the court as evading the questions that are really at the core of the case, as in, what is indeed wrong? The wrong of these transgendered surgeries. May we forbid parents from choosing them for children who seem to be in anguish? What is the wrong of these procedures? And the court holds back from recognizing the objective, inescapable truth at the heart of the case, as Gerry keeps pointing out, that sex is immutable, that these surgeries are predicated on a falsehood. Now, the legislature in Tennessee barred these horrendous, disfiguring, life-changing therapies seeking to remedy gender dysphoria for young people up to the age of 18. The law barred those surgeries even when parents, responding to the passions that were seizing their youngsters, were quite willing to offer up their consent and order these procedures. So the case was indeed brought by parents invoking their parental rights to govern the medical treatment of their children. So the challengers chose to present their case in this more disarming way by invoking the rights of parents, earnestly acceding to the clamor of the children and the doctors. And so you think that one thing we need to get clear on at the very threshold of the case, to meet the challenge, is to explain what the grounds are of those parental rights. And if we get clear on what the grounds are of those parental rights, we could get clear at the same time as what are the tenable grounds for restricting those rights. Now, this is a problem that's curiously been confusing to so many conservative commentators. It would have been as baffling for the founders. The founders understood that for every liberty we mention, there's an obverse side of any liberty we exercise can be directed to rightful or wrongful ends. Our liberty to engage in speech can produce libel, the destruction of reputations, threats, the inciting of riots. So the First Amendment never really established some kind of absolute right to unrestricted speech. Just as our friend Scalia would say, the Second Amendment and right to bear arms is not to establish an unrestricted right to bear arms. There's so many grounds for which we could have plausible restrictions. So it's the need to get clear on were there such things as parental rights, but those are for the conservatives, such as Justice Scalia, because they're textualists. They want to be guarded by the Constitution, and there is nothing in the Constitution about parental rights. For some of the conservatives, this comes in through that strange device of the Due Process Clause, substantive due process. In the old Myers case, Myers versus Nebraska, 1924, Pierce versus Society of Sisters, where the courts sort of invoke the rights of parents to arrange for the education of their children, whether in being instructed in German or having their children in private schools. So the conservatives are reluctant to sign onto some natural right of parents. And so the tendency is to try to narrow the rights of parents as they come through these cases. And so the inclination, even on the part of the lawyers from Tennessee, was to say, well, we just recognize rights of parents to provide for an education. We haven't recognized any such parental rights to invoke any of these controversial surgeries. So in this construction, we don't begin with presumptive rights flowing to the parents for all kinds of things, in feeding and nourishing their children, shaping their moral life. The rights to parents in this construction are simply doled out to them in segments on discrete subjects in the positive law as the court doles them out. Now, if you take the alternative perspective, a kind of a natural law perspective, we take the line of critics of the Bill of Rights at the beginning, like Theodore Sedgwick, we would begin in the character of liberal jurisprudence with the sense that that human person, that being we call the moral agent who can reason about right and wrong, he has a presumptive claim to all dimensions of his freedom, not merely the rights that were mentioned in the Bill of Rights, and the burden would fall to the law as it tries to restrict those freedoms. Trying to restrict my freedom to make a living braiding hair, or my freedom to leave the house during a snowstorm, or leave it meet with others during a pandemic. I mean, there are grounds on which we judge these different restrictions rightful or wrongful. Now, from this perspective, the parents would have a presumptive claim to govern the medical care administered to their own children, and the burden would fall to the government to justify its move to forbid these surgeries. Now, Gerry and I happen to think that there's a compelling case could be made here, much stronger than the case made by the legislature lawyers for Tennessee, because we'd argue that the whole scheme of surgeries and treatments is simply, as I say, predicated on a falsehood. Children aren't assigned sex at birth. They come into this world as males and females, as shown plainly in their organs of reproduction. But this is not exactly what the legislature in Tennessee said. The legislature found that there was enough evidence of the harms done by the procedure, along with the continued prospect of suicide, and that the problem, left in a kind of benign repose, might just dissolve with time. And yet that involved a reckoning of contingent things. So it's not fully clear as to what we say to parents who say, well, they understand the risks, but out of concern to relieve the anguish of their children, they might be willing to risk it. But that's not the kind of claim that remains plausible if the argument is that these procedures are indefensible, untenable, that no one should be free to choose them. But that's not the kind of opinion written by the court, and it opens these possibilities that a legislature in another state could just as freely sweep away the inhibitions on the choice of these surgeries. And here, indeed, the left is already doubling down. What the reaction is, this judgment in Skrmetti is simply the work of a conservative court, and we are free now to take measures to promote transgenderism. So here, I think what Gerry has rightly said in his piece, and I leave it over to swing it back to Gerry now, that the court in this case has not given much guidance to other courts to follow.
No, I think you're quite right, Hadley. I think it would be very difficult, perhaps impossible, to overstate the strategic importance in the Skrmetti opinion of what the court called medical and scientific uncertainty about the value and worth of the pharmaceutical and, at least according to the statute, surgical interventions. The surgical interventions were put aside in this case as not really raised on these facts, but we all know that they're part of the picture of medical transitioning treatments. But very clearly, the court chose, I'm talking about the majority opinion written by the Chief Justice, the court chose, for reasons that I suspect we will explore over the next hour or so, chose to write a ticket that was good for a one-way ride to this destination. And to lay down, as I read the opinion, few, if any, more normative markers. And that's what I mean by the strategic importance of what the court described as medical and scientific uncertainty, which led them easily to conclude that in a situation of that sort, the people and their elected representatives are the repository of final judgment about the regulation of the medical profession. Now, the obvious problem, the first, perhaps you might say the most obvious problem with this way of dealing with the Tennessee statute, is that it leaves, as far as the pathway wide open for state California, for example, which have permissive law and regard these chemical and surgical interventions as therapeutic and indeed life-saving. So that's the first question about Skrmetti. What, if anything, in it would block these permissive laws, and such that in a permissive state, what person withstanding could make an argument against these permissions on the view that although there is some medical and scientific difference of opinion, Nonetheless, there is a firmer ground of normativity with which to cut into this, assertedly scientific disagreement. So that's the first problem. The second problem is almost as obvious that the court, when it decided Skrmetti, already had granted review cert in a case from Colorado, which is of the type that I'm describing now. It's a permissive law in a perverse sense. That is to say, the law in Colorado and Childs versus Salazar is, I would say, extremely pro-transgender. And the statute there has banned psychological and psychiatric counseling of any minor undertaken for the sake of or with the aim of, this is the language of the statute, changing that child's sexual orientation, gender identity. So to put it plainly, and I recognize there are some qualifications that would have to be added in a more careful and extended discussion, but the court has before it already a case that raises the question of, well, what if a state such as Colorado takes a very different view of the medical and scientific evidence, different view than the legislature in Tennessee, and Colorado has judged that what I'll call talk therapy, for the sake of not so much changing anyone's gender identity, but rather clarifying and helping one to come to some kind of peace with one's sex. Colorado obviously thinks that's quack medicine, unsound, ineffective, and even dangerous. Now, the question then is, what, if anything, the court will be able to muster? What resources does the court have to defeat, and the complaint is brought in that case by someone who would indeed engage in this talk therapy for the sake of clarifying gender identity, or as the statute has it, changed gender identity. But the point is, the court has left itself right now very few resources to do that. I don't think there's anything in Skrmetti that will help the court. Now, the court will, in that case, probably manipulate doctrine on free speech doctrine, and perhaps muscle its way to a sound result. But that will just compound the problem, so to speak, of Skrmetti. The court finding a pathway that seems plausible to the right result without taking on the nest of normative questions that are present in all of the transgender cases.
So let me just get clear again on that point, Gerry. If the court had taken the position closer to what you and I have been arguing for, there's something just in principle wrong about these kinds of surgeries. They just should be inadmissible. If that had been on the books as they come to face Childs versus Salazar, then Ms. Childs would have a ground of argument.
Right.
What I'm simply offering here is advice that aligns the understanding put forth by the court that no one should be allowed to choose these surgeries.
No, that's quite true. That's quite true. And indeed, Colorado ought not to be in a position to ban what is the sound medical scientific approach to gender dysphoric children, which is to help them. I mean, these are children who need help for sure, but they're not helped by the medical establishment buying into their delusion and transitioning them to an impossible state of affairs. So the talk therapy is really the sound way to go. And Colorado asserts that it's quack medicine. I doubt that the evidence supports that view. But the problem created by Skrmetti, at least in this regard, is that it's not so much a matter of whether there's substantial evidence compiled by Paul McHugh, among many others, that indeed talk therapy is the way to go. The problem created by Skrmetti is that the presence of aggressively pro-transgender medical establishment opinion creates what the court is calling a state of medical and scientific uncertainty, and that where you have medical and scientific uncertainty, the court in Skrmetti certainly seems to be saying it is not for the court to judge who's right in that dispute, but rather to judge who gets to decide who's right in that dispute. And the court says that it's for the people and their elected representatives, which leads straight away to the wrong result in Childs versus Salazar, unless the court is to, as I say, muscle free speech doctrine into a shape that allows the court to rescue from the jaws of defeat the right answer in Childs versus Salazar.
I think I've thought for a long while that this approach through arguing the matter as a matter of speech is just utterly implausible. The response on the part of the government in Colorado is, you see, we understand deeply rightful about these kinds of surgeries. People should have them accessible to them, and the kind of speech that discourages people from seeking it is inadmissible. The other side of it is we recall with when Rust versus Sullivan years ago, even Justice Souter, when the government barred people working for the government to promote abortion. The position of the government is no, we don't regard abortion as something rightful to be promoted. So yes, we're putting restraints on the freedom of people working for the government to recommend these surgeries. So that would be the response of the government of Colorado. And as you say, the courts have not provided in Skrmetti any ground to resist that claim.
No, and the court also has agreed to review, that is to take up next term, a case of ethic competitions, cases arising in Idaho and West Virginia, and the question of whether states may limit participation in girls' sports to people who are actually girls and exclude from girls' sports boys, even young men, who are identifying as women. Now, that, again, is not a case about medical intervention, it's true. So I think those two cases, are out there right now, unmoored from anything in Skrmetti. It'll be almost as if the court has to, invent the wheel in those cases and probably undo what it's done in Skrmetti up to a great point to get to the right result in Childs versus Salazar. Now, there are some ports in the storm here, which the court, I think, in Skrmetti should have, and going forward should, sort of steer itself into these safe harbors. Now, one, which I think is low-hanging fruit for the court, it's a point that the court has effectively affirmed over the years in a variety of cases. Now, even Skrmetti, in her concurring opinion, Justice Barrett mentions that sex is immutable. In other cases over the years, the court has affirmed that sex is binary. It's just male and female, and also that it's innate. Now, the court, when it does so, to distance itself from the metaphysical truth that sex is innate by describing sex as, well, by that we mean biological sex. Again, distancing itself a bit from the metaphysics of the person by, you might say, putting an asterisk around the truth that sex is innate by saying, well, that's the biological matter, holding in reserve or putting aside for the moment whether, if your body is female, does that make you female? But nonetheless, with that caveat, the court has affirmed that sex is innate, binary, and immutable. And I can't think of a good reason why, though, that triple truth should not play the role that it ought to play in analyses like Skrmetti. But again, the court was obviously of a mind to affirm just about nothing of a moral or metaphysical normative nature, and to resolve this case on the most modest grounds that seem to them to be available. Now, my judgment is that Skrmetti certainly reaches the right result. Those modest grounds are actually inadequate. And although it's fair enough to say, true enough to say, that the court ought to resolve the cases before them and not reach out and decide cases that are yet to come before them, that's true. But they do need to provide adequate and cogent grounds in the case before them. And I do think on several scores, Skrmetti fails to do that.
Actually, there's a point you made at the end of your piece in Humanum. And by the way, I should point out to people, Gerry and I both did pieces for the journal Humanum on Skrmetti. And Gerry's is just a marvelous piece that really takes the matter from every angle and really goes to the root. And Gerry, you pointed out something that keeps coming, the people countering the arguments I make. They say, well, the court never addressed that question. And you pointed out that sometimes the litigants will neglect to make the strongest case because they don't think the court could understand how to deal with it. It makes more sense to feed the judges the formulas they're used to working with. And that with the lawyers from Tennessee did not give the court the possibility of recognizing that just something deeply wrong and inescapably wrong about this whole scheme. And in fact, we're getting some reaction. We've just had some response from Jonathan Skrmetti, who wanted to talk to us about maybe to meet with the team down there to make consider in the response to the arguments we've been making that maybe they could have made a different argument here. Gerry, you were as baffled as I was by this John Roberts' way of trying to insist that no, sex really did not bear on this question, that we simply barred people from choosing the kinds of therapies intended to ease the transition of a male into female, female into male, but we're barring people of both sexes from doing it. There's no discrimination here on the basis of sex. This, as I said before, this has a chilling echo of the line offered to us in the past by Lyman Trumbull back during the 14th Amendment, when he was trying to assure his colleagues that nothing in this amendment is going to challenge those laws in Illinois as well as Virginia that barred marriage across racial lines. He said, no, there's no discrimination on the basis of race. Blacks are barred from choosing white partners as whites are barred from choosing black partners. And the court, in fact, the Supreme Court stayed with that position well into the late 19th century. But I find a kind of echo from this. But John Roberts tried to reconcile all this with Bostock. And what did you make of that?
Well, I know the court did take up the comparison to Bostock because the litigants all but forced them to do so. My own judgment is that the court's treatment of Bostock, although not meant to undermine Bostock, in fact does. Now, surely the court stated correctly that Bostock has yet to be expanded or exported beyond Title VII, and that is true. But the reasoning of Bostock is to a large extent, not entirely, but to a large extent portable to other areas of the law where sex discrimination is alleged. And I think that the court's handling of the substance of Bostock as applied to the Skrmetti facts really undermined the reasoning of Bostock. Now, Justice Gorsuch joined the Union, did not write separately. And as we mentioned in an earlier episode about Skrmetti oral argument, very unusually, maybe uniquely, Justice Gorsuch was entirely silent during the oral argument. And of course, he's the author of the court's opinion in Bostock. I don't know, I have no idea what it means, particularly for Justice Gorsuch, for the Skrmetti opinion to go the way it did and to subscribe to it without any additional comment and a concurrence. But I do think that Skrmetti undermines the soundness of the reasoning of Gorsuch and the court in Bostock. And for that, we should be grateful. But the Chief Justice in Skrmetti, took up the, I think, juvenile argument that is immature, clever, not even very clever, argument in this case and elsewhere that there is sex discrimination, at least because boys can take puberty blockers, but girls can't, or boys can take puberty blockers for the sake of delaying a precocious puberty, but they can't take it for the sake of transitioning or for taking the time out to decide about transitioning. And with estrogen and testosterone, the simple, that is not too clever argument is that, well, girls can take estrogen, but boys can't. And I think the Chief Justice does a good job in showing the one fallacy in that way of thinking. And the fallacy is that it's not really a matter of the raw medical behavior, that is administering estrogen to a female child, but rather what exactly is the medical act of which that is the behavioral component. And the act that we're talking about really, as the legislature stated plainly, is you can't do these things, administer cross-sex hormones or puberty blockers, for the sake of enabling a child to transition to a sex other than his or her own. Now, that's what gives you the real substance of the Tennessee statute. And that is, once you get a hold of that, rather obviously sex neutral, or not sex discriminatory. To put it in my words, although I think here I'm trying to track what the Chief Justice says, and I think I do, it's really the following proposition. And this is the way to think about the Tennessee law, and to think about it in a way that sort of effaces or erases the sex discrimination idea altogether. Tennessee is saying, look, no one at all may take these medications, puberty blockers and cross-sex hormones. Nobody at all may take these medications in an effort to repudiate their sex and to live in accordance with a delusional identity as a member of the opposite sex. Now, that is in effect what the Tennessee statute forbids, and it is in effect what, in so many words, what Chief Justice Roberts affirms Tennessee has done and may do. And when you think of it that way, again, no one at all may these medications for the sake of repudiating or in an attempt to repudiate their sex and adopt a delusional identity. Now, that's exactly right. Now, what the court studiously refrains from doing, and here, to get back to one of your other points, Hadley, the Tennessee legislature, in light of a long history on the Supreme Court, a minority enthusiastically endorsing extravagant arguments of the sort made on behalf of transgender plaintiffs in these cases, or the parents thereof, and a conservative majority on the court, which has shown itself time and again to be nearly allergic to critical moral reasoning and to anything that to the conservatives sounds like philosophy or metaphysics. I think the Tennessee legislature, rather in a coy way, slipped into its findings, among other findings about regret and medical uncertainty and medical evidence, slipped into its findings the normative judgment that their objective of the statute was to help children come to a peaceful relationship with their sex and to avoid disdaining their sex. Now, that's about as far as Tennessee dare go in the atmosphere of what I'm calling moral allergy on the Supreme Court. Now, that's an example of what I think we mean when we say, although, and we know, both of us know very well from talking to so many judges over the years in James Wilson seminars, that even judges with perfectly sound moral understanding of what's at stake in this case or that case will say that they can't take the more bold moral position that you and I, Hadley, often recommend to them because the litigants didn't raise it. And the point that we're making is, yeah, there's a reason why the litigants didn't raise it. It's because you've already made it clear you're not receptive to the argument that they're not raising. So that's, you might say, a vicious circle, vicious rhetorical circle, and it amounts to a trick, a debater's trick. You didn't raise it, so I'm not going to talk about it. But yeah, we didn't raise it because you've made it clear you don't want to hear it. And that's true of the Skrmetti. I dare the Tennessee lawmakers who enacted the statute hold the healthy and sound view that a child is harmed, damaged morally and physically by these interventions, and that indeed it is a delusion to seek to be a member of or identify as a member of another sex, and that to alienate oneself from one's body is to create a dissonance inside of oneself, which is not possibly ameliorated by trying to become a member of the opposite sex, but can only be ameliorated by helping that child to come to an acceptance and embrace of who they are. So again, here, the argument that should be made, but is understandably not often made because of the courts, especially the conservatives' reticence about moral matters, is that we are our bodies, and that anyone who repudiates their sex is in a fundamental way repudiating themselves. Now, this deep dissonance, which is like gender dysphoria, is a condition which can be treated and should be treated, but only by trying to, you might say, recompose or reintegrate the person, not by abetting a person's further attempts to divide themselves between, let's say, as it's so often said, a female gender identity and a male body. That's to create a division within oneself that is simply a harm. It is simply harmful.
That is what the firmest ground of the judgment. But that's not what the court said. Is the court, as you say, the legislature had made a normative judgment, but neither the court nor the legislature established the ground for that judgment. Now, you made the point for both of us in your piece. You're saying, urging these people to some of the confidence to make the larger argument. You're making the point for our team that the reason for doing it is to produce a more coherent account of what you're doing. So just let's go back for a moment to that old argument about Lyman trouble. The 14th Amendment does not bar these laws that in turn bar interracial marriage because it bears equally on both sides. It bars whites from marrying black people and black people from marrying whites. And the court here is saying, no, both males and females may be barred the use of this. What the court didn't, what was the issue, of course, in miscegenation and that issue of interracial marriage is that, yeah, you can bar people from both races from making this. It bears equally on that both people of both races. But what is at issue here is the notion of interracial marriage itself. You will not accept the validity of this. In the same way, the court is saying here, you may choose, you may, both males and females may be barred equally from choosing this thing, but what they don't explain is what is wrong about the thing that they're choosing. So they have no response to Justice Sotomayor in her dissenting opinions, where she recalls one case. She says, Ryan began to find his voice again. Sotomayor accepted the change in sex here as an accomplished fact. Ryan began to find his voice again. He started raising his hand in class, participating at school. For Ryan's parents, it is simply not an option to cut him off from this care. I worry about his ability to survive. Now we have parents signing this, or they're just desperately worried about their children. They say, we don't know if it's going to work, but we're willing to take the risk. Now tell us why we may not take the risk. And the legislature said, well, we think that this thing has many risks, and you're likely to render the children sterile without any lasting gain. They said, well, that's your assessment. What is it that bars us from making this choice for our children? There, I would claim they needed to say something stronger. They needed to say exactly what you've been saying, Gerry, about you're separating yourself from the way you are indeed constituted.
Right. Well, there are a couple, or at least a few things I can think of that would be parts of a response to that position, the position that Sotomayor adopts, takes over, and embellishes. In general, Sotomayor seems to take the view that, as I would describe it, look, these kids are feeling better. They're feeling better and they seem to be doing better. But that's not really medicine. I mean, you can help a patient, someone with an underlying problem or condition can be made to feel better in the short run without there being any actual genuine benefit provided to that person. So that anybody, even the administration of a placebo, can lead to people in the short run saying, I feel much better now, but no genuine benefit has been provided to that person. And with regard to suicidal ideation, I would invite listeners to, if they're inclined to, confirm by looking up the numbers, what I'm about to say. There are plenty of children who are diagnosed with gender dysphoria who are in a very bad state psychologically, and many of them may well have thoughts about suicide. But my understanding of the numbers is that suicidal ideation, once you really look at it over even a relatively short period of time, even after these interventions are administered to gender dysphoric children, I don't think the frequency of suicidal ideation decreases. So that suggests that the source of the disquiet and distress, including suicidal ideation, I don't think the source of it is the gender dysphoria itself, but underlying condition which is manifesting itself in gender dysphoria. So anxiety, depression, lack of social adjustment, friendlessness, some other underlying condition. But the thing about the child who may in the short run seem to feel better. And I don't think that's actually the way the practice of medicine ought to be organized. And I don't think that the numbers that are often produced to back up the claim that these children are better off, those numbers really bear out the claim. But more importantly, it's a question of a mind-body disorder, a disunity between mind and body. And when you realize that no one can actually become a member of the other sex, that what we're talking about is a pharmaceutical regimen which is designed to some extent, produce a feeling of being a member of the other sex, then you can really begin to see that that's medical quackery. That is, to pharmaceutically sustain a delusion. I don't know if that's the definition of quackery, but if it's not, it's a good example of quackery. And underneath all of this, or at the heart of the question about transgender youth, and probably the heart of any rebuttal of Sotomayor's position, is the question about the nature of the human person and whether we really are a unity of mind and body. Now, if it's true that we're not, if it's true, as I think Sotomayor is supposing, that the real person resides in a psyche and an imagination, and the body is a kind of appurtenance there too, well, then it's a different conversation. Then it's a different story altogether. So in the end, the differences, so to speak, between Sotomayor and the majority depend upon the truth about human persons.
Exactly. Now, the common sense thing, in other words, is, as you suggest, is you have all these maladies and difficulties. Why don't you try to treat them through other devices? Maybe the child is depressed. Why do you fly now to a procedure that is just radically at odds with the way we are constituted? This reminds me, you just brought back this scene from over 40 years ago when I was invited by my friend Nachman Greenberg back to Chicago to Michael Reese. We had a program on child abuse, and the clinicians thought that if there's a problem here, it must be manifesting itself in some kind of material hurt. So they didn't know what to do with the father who's saying that since he and his teenage daughter have been having sex, her acne's cleared up and her grades have improved. So what came as
Right.
a revelation for them is, people their cheeks could be rosy, they could be flourishing, there could be something in principle wrong about the central problem here. Now,
Exactly.
you made another important argument of yours. You made the point to me in our other conversation that, well, I put the accent initially on the problem. Look, this case was cleverly framed by the litigants as a matter of parental. Are you really going to tell parents that who have authority to direct their own children, that they can't really make decisions about the well-being of their own children, what kind of medical treatment they get? Everyone recognizes parents usually have those rights. Are you telling me we don't have them? And you pointed out that, the court never really addressed that question, which I took to have been the threshold question there, and the one that really leads into the main problem. Well, can you tell me why you're justified in barring parents from choosing something that they see that might relieve the anguish of their children? Because, as you point out, they didn't discuss parental rights. Now, there's an old line that Leo Strauss used to draw from Machiavelli in the Discourses, that when a wise man preserves silence on a matter that everybody else thinks is important, he gives us to believe that it's not really quite as important as you thought. Now,
Hmm.
this charge with that, my own sense of things, that over the last few years, I've said, I can't believe I'm living in a regime in which parents could be threatened with a loss of custody over their children if they seek counsel for a child who's suffering confusion over his sexuality. I didn't believe, I assumed there were these parental rights. But what's the court now telling us? Don't worry. No, we don't regard those parental rights as very serious. Now, what do you take this to mean? Let's say I begin with the notion you're going to have to make a strong case to show to the legislature is going to have a burden in showing why they're going to be justified in threatening the loss of custody for parents who seek counsel for their children. And now the court telling me that no, we don't start with any presumptive plausible claim of mine as a parent. Are they telling us, no, we just don't take parental rights seriously? Is that what they're telling us by the neglect here? Or they're telling us they just don't want to go into the weeds on what they consider substantive due process? I think, what do you make of this, Gerry? That they're willing just to avoid that question altogether. It's
Well,
a
they did.
compelling avoidance.
Well, they surely did. And most listeners will know that in the Sixth Circuit below, the matter of parents' rights was litigated quite fully and forcefully. And Judge Sutton's opinion took it up and handled it very deftly and rejected the parents' rights claim to have access. I'm trying to think of exactly how Judge Sutton phrased it, but I think his conclusion was close in phrasing close to these words. Parents have no right to access medical treatments that are reasonably banned by the state legislature. And I could recommend, Judge Sutton's treatment of the question, but the Supreme Court granted review, cert, strictly on the equal protection question and put aside entirely or did not take up at all the parents' rights question. It's a fair question as to why it did so. My opinion is that the court doesn't know what to make at this point of parents' rights. Even the case from Montgomery County with the grade school readers about LGBTQ. It's really, that comes out as a free exercise case more than strictly speaking a parents' rights case. My guess is that the court hasn't figured out what it wants to do with parents' rights yet and is not going to say much about parents' rights until it does figure out what it wants to say. I think the conservatives on the court, I don't know what the liberals on the court think about this, but the conservatives on the court will have the way in which I think intuitively they're in favor of parents' rights. But as skilled justices, I think they would take up the question of parents' rights with a guilty conscience, meaning given what else they've said about substantive due process, including jobs, I think they are a bit embarrassed by the creation of a substantive due process right of parents, recognized or articulated for the first time in the 1920s and only developed sporadically in the decades since. It's not to discredit. I'm not saying that that entire line of cases is unsound. I don't think it's unsound, but I do think conservatives have they're ambivalent about that line of cases. So I think for the moment, at least, they're wary of taking up cases that present squarely parents' rights issues. Now, my own judgment about what would happen in a parents' rights case, given the facts of Skrmetti, I myself hold open the possibility that in a future case, a set of parents alleging religious grounds or just parental rights grounds might be able to gain an exception to any state law that banned these procedures, such as Tennessee, for their child. So I think as applied, parental rights exceptions to restrictive laws like Tennessee's are in the mix very much. Now, the court in Skrmetti didn't take up the question of parents' rights, and I don't think said much of anything that's of value in assisting lower courts to handle those questions. I will offer up my own judgment that the source of the limit on parents' rights, the main source of the limit, and the reason why, even as applied, parents don't have a right to obtain these treatments for their adult minor child, is that these treatments, both pharmaceutical and surgical, or the Trump executive order refers to chemical and surgical mutilations. I think, in fact, in truth, these treatments are mutilations, and no parent has a right to mutilate their child.
Right. Now, well, look, well, the question is, well, they're so recent. Why are they so recent? Because they came up in the 1920s. One reason that they're so recent is because why would anyone at the founding think it necessary to stipulate in the Constitution that parents have a presumptive authority over their natural children? It just wouldn't have occurred to them. I guess it's worth stating again. We have here that matter of substantive due process. I invoke again the great Thomas Cooley, who insisted that the due process clause was simply that fine device by which judges may draw into the law those those precepts of common sense of natural law that, of course, the founders never thought it necessary to put down. Our friend Dick Helmholtz, again at the University of Chicago Law School, says, "What about a summons? A summons. When people are targeted for prosecution, don't they have a right to be alerted? Isn't a summons part of the natural law?" Sure. If so, Cooley would say, yeah, if the judge invokes a summons, or if Cardozo later says there should be a trial before a verdict, he's simply drawing out the implications of what we should have thought were there all along. So why is the question why the court treats this matter, parental rights, as I just pointed out that from a perspective of natural law, it is not as much of a mystery, nor is it a mystery that parents having rights to direct their children will also have abilities, and the things they may not rightly choose. Now,
Right.
you have made the deeper argument, and I don't know how much time we have to pursue it, but it's certainly the argument that completes the whole thing. Gerry, you've made that this whole matter of parental rights has to be seen through the lens of what is a marriage, right?
Right.
That those rights may flow to you as you have taken responsibility. You've committed yourself to a union. By committing yourself to a union through the law, you've foregone your freedom to quit this association as it suits your convenience. You're taking responsibility. That line from Isaiah, "Fear not, I've redeemed thee. I've given you my name. I've given you my name." Because it makes a profound difference when a marriage is understood in that way, and the rights of parents flow to us through that scheme.
Right. Well, I think that's quite right. And well, one reason why the term parents' rights was not only omitted, so to speak, from the Bill of Rights and the Constitution, but my guess is that you'd look a long time before you discovered the term parents' rights in Blackstone or even Cooley, for that matter. And that's because you're dealing with writers who wrote during a time when what we call parents' rights would be something related, but conceptually very different, and in some substantive ways very different. And that would have to do with the incidence of marriage. That what we call parents' rights really is a variation or a sort of descendant of marital rights. And today, since we know for a fact that we don't really talk about marital rights in the same way we used to, of course, but a complicating factor today is that the talk of parents' rights without rooting them in the marital family is to take up a subject that is much more fractured and difficult and I think ungrounded than the trajectory of marital rights over the centuries. So put that a little bit differently, to talk about parents' rights today is not to talk about the incidence of marriage and what children are in relation to the parents. The children, in the traditional terminology, were the issue of the marriage. The children were understood in law to be of the marriage. But now, when you have non-marital sexual intercourse, artificial action, the breakup of families and the recomposition of melded families, now parents' rights is almost like a hornet's nest of contending claims about the one child, which you didn't have in eras when divorce was rare. There was no such thing as artificial reproduction. Illegitimacy was not unknown, to say the least, but the father of an illegitimate child had few, if any, rights in the law, so that in contemplation of law, children went with a marriage, and that had itself a unity and a coherence and a strong, deep philosophical basis, you might say. But we no longer have those bases nor that depth. So parents' rights today are really the rights of individuals who have some relationship, biological or otherwise, with a child. And those individuals are as often as not unmarried, that is, not married to each other, and have contending ideas about what to do with that child. So to take it back to Skrmetti, I don't know what the Supreme Court would say, or the Supreme Court of Tennessee, or any court would say. Let's take an example of some child in some child whose parents were plaintiffs in this case. Let's say that child, one of those children, let's imagine this, one of those children has a mother who wants to go all the way through to surgery, but has a father who's no longer married to the mother who's completely opposed to that. What result? Does the father have a veto over such experimental treatments of his son, let's say? Or does the mother have the paramount right to direct the medical care of that son? I don't know what courts would do, but that's an example of what I mean when I say that the question about parents' rights today, in truth, bears little resemblance to the matter of marriage and marital incidents of yesteryear.
So
So, so,
just connected again to my point. Let's say we have a father who objects. Either he's trying to get permit to order up these transgendered surgeries for his child, or trying to resist them. It turns out he never married the mother.
Yeah.
He never married the mother. Now, from a natural law perspective, we say no. He's simply invoking his claims as the natural parent. Remember my old line about this, those old lines, the injunction, biblical injunction, honor thy father and thy mother, could not be referring simply to the biological father or mother, because in that case, we'd be enjoined to honor the man who sired us in the course of a rape. It
Right.
makes sense if it refers to the parents who fulfilled the moral definition of parenting, who were there to nurture and protect. So now we have somebody coming in to try to order up the surgeries, resist, but turns out no, he never said those words. I take responsibility. I'm giving you my name. He's never stepped up to take responsibility. We'd say no. He may be the natural father biologically, but he doesn't rise up to fulfill what we say is the natural law understanding of what should constitute the father in this case. So, but where now? So, in other words, what we've been saying here is that there have been the legislation makes sense only if we thought there was a normative ground for the judgment that children should not be separated, be under the illusion that they're separating themselves from the way in which they're constituted. We've made a normative judgment, but we're reluctant to put in place the inescapable objective truth that makes that judgment compelling. So we have that. And so where are we with... So, Gerry, tell me, where are we now if we have, when they come to face the question of now a father being a mother, a father, or parents objecting to the possibility that they're going to lose custody of their children if they seek counseling? What do you take to be the stance of the court right now? That they don't know what to do with it? That claim is a kind of a non-starter? They don't know what to do with it?
Well, I think it is, you teeing it up just right. It sounds perhaps melodramatic the way you put it, Hadley, but it nonetheless is quite apt. I mean, take the Colorado law and the Tennessee law and just put them side by side. Now, I recognize Colorado is talking about talk therapy. Tennessee is talking about pharmaceutical intervention, surgical interventions. But nonetheless, I think the following way of putting the matter still stands and is illuminating. Tennessee thinks it's child abuse to go forward. Colorado thinks it's child abuse not to. Tennessee thinks it's Tennessee says we need a red light to prevent child abuse. Colorado says, no, we need actually a green light to prevent child abuse. And there you are. Now, what is the Supreme Court going to do? I suspect they'll do what I think they've been doing and probably will keep doing in some other areas of the law. Church state is certainly one, where the court is not prepared to articulate, consolidate the decisions that's reached in church state cases over the last 20 years, and just provide a new set of foundational commitments going forward. In other words, the court in church state has rejected secularism, rejected Lemon, but doesn't want to take stock and set some normative foundations, rather talk about history. So I think the court is going to muddle through on church state for the foreseeable future. I think the court is muddling through on questions about the Fourth Amendment when it's inherited concepts or struggling to deal with a digital era. The court in Paxton, the age verification case from Texas, the court employed analog concepts in a digital case. I think the court, a case where the majority opinion was not strong because it was to remain within the safe harbor of doctrine from an analog age. So I think the court is muddling through with free speech in a digital age, especially with regard to obscenity, muddling through doctrinally in church state, search and seizure. And I think it'll muddle through these cases meaning transgender cases, for the foreseeable future, manipulating doctrine as need be to get to, as often as not, the right result. But it will leave behind a trail of jumbled and often incoherent holdings and just make the best of it going forward. So I think that's the situation we're in so many of these areas of the law. If we're fortunate, and I suspect we're not going to be this fortunate, the court will begin to ask questions about Obergefell, because that's left behind a wake of incoherencies in the law. But again, if the court does even consider, not overruling Obergefell, but just about proper limits upon the Obergefell holding, what the meaning of the Obergefell holding is, the court hasn't touched that question really since 2017 in Provon versus Smith. I think the court will, if it does do that, revisits the scope of the Obergefell holding. It'll be fittingly on shallow foundations, moving in the right direction, but without any real anchor and normative commitments that can be defended.
So what you've got here, you might say, is a play on that old line. We have 6 characters in search of a play.
Yeah, well said.
But you're saying that they muddled through on this one. They gave us what we think is the right result, but with no guidance for the cases to come, no help for Miss Childs, who's going to try to offer advice to counter surgery. She has nothing on her side. So as we say, it's you pull that old line from Frankfurt. Well, we're muddling through. We resolved this case, but all we've got is a ticket for this trip out.
Yeah.
It doesn't disclose anything that we're going to do in that. So, okay, but this again, it's a case of 6 judges in search of the scheme. Alito, remember in Bostock, Alito pointed out right away, this holding is going to bear instantly in locker rooms and bathrooms.
Yes.
And they no, and it was. It was not a months or weeks before it was. And so what is the curious understanding? You think you could articulate a point here, a principle that it's that if you refuse to recognize Anthony Stevens' understanding that he's converted himself into female, if you refuse to respect that, you've committed an offense. And why do you think that principle will not fly to other cases, or is confined only to matters of employment? As they try to muddle through, they have to keep narrowing these decisions. They can't quite give us the scheme. But no, Gerry, I think you've made the case very persuasively what the deep ground should be for these judgments. And I think we've tried to map out what the difference is, a natural law perspective or the thing we're getting as the judges are trying to muddle through.